And joining us now, Jillian Siskind. She is the president of the Canadian Lawyers for Human Rights and a former prosecutor with the Department of Justice. And we welcome you to TVO.
Thank you very much.
Nice to have you here today. Okay, we're going to talk about Desiree Munyaneza, whose trial took 2 years and cost Canadians $1.6 million to prosecute. First of all, who is he and what did the court conclude that he did?
Well, you would recall, and your viewers are certainly familiar with Romeo Dallaire, the Canadian senator who was a witness, one of the only Western witnesses to the genocide in Rwanda in 1994. Desiree Munyaneza was one of the players in that genocide. He was found to have committed numerous killings, rapes, beatings, looting. He was the leader of one of the Interahamwe groups. The Interahamwe was a youth militia. And in particular, this was in the Butere prefecture where Munyaneza's family was from. There were a number of witnesses to his rule. There was one particular witness, a woman who had been taken refuge in a church. A number of Tutsis had gone to a church to seek refuge, and a group of the Interahamwe arrived, including Desiree Munyaneza, and systematically slaughtered all of the Tutsis inside the church. They were then put in sort of a pile to the side of the church, and this woman who was the witness in the case was left for dead, and in fact stayed in this pile for 3 days until she could escape.
Smeared blood all over herself,
That's right.
To pretend to be dead.
That's right.
And she managed to survive
That's
as a
right.
result. Okay, the next question is, obviously this man was convicted of having created, atrocities against humanity in an African country. So why was he on trial in a Canadian courtroom?
Well, Desiree Munyaneza had left Rwanda. He came to Canada in 1997, claimed refugee status. He was refused. The RCMP at that time started looking into his role in the genocide, and they conducted an investigation. They went back and forth to Rwanda, spoke with people from the tribunal, and Canada has the authority to try international criminals who are located in Canada for international crimes.
So that's why we tried him here.
That's exactly why.
Why was the International Criminal Court, which Canada believes in and supports, why was that not an option in this case?
Well, the International Criminal Court is a court of last resort. So the countries who are wishing to charge someone and have a complete trial would have no need to send someone to the International Criminal Court. It is used when a country is unable or unwilling to try them themselves. And in this case, Canada had the ability to do it and the willingness to do it.
Well, he was the first person, I gather, charged and convicted under Canada's War Crimes and Crimes Against Humanity Act.
Yes.
How does that work?
Well, when somebody has committed a crime abroad, one of the international crimes, genocide, crimes against humanity, or war crimes, and they have a connection to Canada, but specifically they are in Canada, then the RCMP has the jurisdiction to investigate this crime and try them under Canadian law inside the country. I want to read a quote to you from a guy named Tom Quiggin, who's an ex-intelligence analyst for the RCMP's War Crimes Unit. And here's how he put it. He said, if I were working as a consultant for war criminals, what I would tell them is that Canada is probably the best place to go in terms of avoiding prosecution and in terms of avoiding deportation. Is he right? Well, I'm quite familiar with Tom Quiggin. Actually, I've sat on another war crimes panel with him, and that is definitely a very commonly held view, certainly in the past, and I know that particular quote from Mr. Quiggin was taken from an article a couple of years ago, and that was probably justified to a certain extent, but not for such sinister reasons. The Canadian justice system is very fair and open, and we have due process. So refugees and immigrants and that is the mechanism through which many war criminals enter Canada, they have access to full due process. And that's important because Canada doesn't want to slam the door on legitimate refugees who have a rightful claim. Unfortunately, however, it's also been used to the advantage of people who have maybe created refugees themselves.
So do you think Canada pursued this case, in the case of the Rwandan person, because they were trying to do something about that reputation?
Absolutely, absolutely. Yeah. And I think it sent a very strong signal that Canada will no longer be a safe haven.
How do you think other countries are viewing Canada's decision to prosecute in this case?
Well, Canada is not the only country that does this. I think that this has been a great move for Canada on the world stage. This is certainly the first conviction for crimes against humanity in a state court or a domestic court. I think that this brings Canada's credibility up quite a bit. We've had great success in the immigration regime and through that process, but at the same time, this is a little bit stronger. You know, the possibility of going to jail for life is very real. And so I think that it has strengthened our reputation and our human rights record and saying that impunity will not be tolerated and this will not be the safe haven it once was.
Although, Jillian, it was a long road to justice, right? I mean, the RCMP spent 5 years investigating this thing before they laid charges. Why do you think it took that long?
Well, Steve, this was the very first case that Canada has done. This is not the usual run-of-the-mill criminal prosecution that is run by the state. It was also done, a lot of the witnesses were not in Canada, they were in Rwanda. They needed cooperation with officials abroad. And for Canada's first prosecution under this legislation, I think they rightfully wanted to make sure they had all their ducks in a row before they went forward.
You know what? I've got the ducks here. Let me make Michael, let's bring this list up here because there were numerous challenges in this case that made it difficult to prosecute. First of all, witnesses had to be flown from Rwanda to Montreal, where he was awaiting trial in jail to testify. The legal team in this case traveled to France and Belgium and Tanzania and Rwanda to hear testimony from witnesses who couldn't make the trip. Many of the 66 witnesses testified behind screens or closed doors under the cloak of anonymity for fear of reprisals. The alleged crimes were committed a decade ago, so of course, memory being what it is, the facts were potentially muddied in the case. Witnesses testified in French, in English, in Kinyarwanda, one of Rwanda's official languages, and that required the use of interpreters. Many of the hearings were held in secret or in camera without the public or the media present. So when you take all of these challenges into account, do you think Munyaneza got a fair trial?
Oh, I absolutely think he had a fair trial. I think that a lot of, for example, the protections for the witnesses, that's a very important part of a trial of this type of a crime, and this certainly occurs at the international tribunals, the ad hoc ones, Yugoslavia and in Rwanda. There are very serious security concerns for the witnesses to come forward, and in order for them to be willing to do so, you must provide some kind of protection for them, for their identity. I think the fact that the court went to the places where the witnesses were to see the setting where the crimes took place and where these witnesses were provided a very ample opportunity. There was full opportunity to cross-examine all of the witnesses. All of the due process that found in Canadian law was applied to this case.
We have, I think, dozens of war crime files open, right, and active in this country right now. What are we doing about those?
Well, it's my understanding that they're being investigated. I certainly don't know for sure, but I can certainly estimate that once we have this, now that we have a successful conviction under the Act, that there will be others to follow shortly.
But I presume they need more resources, more everything, right, in order to prosecute?
Well, absolutely. Absolutely they would, but at the same time, there's a little bit of a roadmap or framework from which to do them, so I would imagine they would take less time than this first one.
Okay. Spain is one of the countries prosecuting cases using universal jurisdiction, and we remember the Augusto Pinochet case, the former Chilean dictator, but it may be that Spain is trying to halt such cases. And I want to read something that came out last month or a few months ago in the Wall Street Journal. Here's an excerpt. The investigations by the judges, who are independent from the executive and legislative branches, have become a growing headache for the Spanish government. The Chinese government warned Spain that bilateral relations could be damaged over the case regarding Tibet crackdowns. The Israeli government strongly criticized the investigation into its 2002 attack on a Hamas leader, which killed 14 other people. Israeli Prime Minister Benjamin Netanyahu said the case, quote, makes a mockery out of international law. How much politics is being brought to bear in the decision to prosecute these cases which have some kind of universal jurisdictional aspect to them?
I think an enormous amount of politics is being brought to bear, but at the same time, I think it has to. Your universal jurisdiction doesn't operate in a vacuum. Every state needs to exist within a community of other states. The law is only but one of a number of tools that a country has to prosecute people, or even to send a message to another country that they don't agree with what has gone on and they believe they have committed crimes, or individuals from that country have committed crimes. I think that despite the political influence, I think that universal jurisdiction is being used, but probably and wisely being done so selectively.
Selectively, okay, but universal jurisdiction sounds like a wonderful theory, except when it runs headlong into the realities of politics. And if, for example, the Chinese and the Israelis and presumably other countries as well are putting pressure on the Spaniards to, cool it, how effective is this thing really at the end of the day?
Well, universal jurisdiction is one of them. I don't know necessarily that trials are going to be the answer either. They are one of a number of ways to deal with this. That said, universal jurisdiction is still very important, and it is integral to the international law system, but it's certainly not the only one. And I think that we have to look at it through the lens of the realpolitik and international relations, that there are other ways to influence countries. The law is one, but I don't think that the existence of politics in these kinds of decisions in any way takes away from what universal jurisdiction can do, but it gives it a reality check.
Well, here's where it's getting really sticky. Here are Jorge Heine and Ramesh Thakur, who's been on this program a few times, writing in the Ottawa Citizen last April. The U.S. angle. Should there be no public accountability for possible crimes of torture authorized by senior U.S. officials in either domestic or international fora, there will be a doubly deleterious consequence. Would-be torturers will know they can escape the consequences, and the embryonic institutions of international criminal justice, such as the International Criminal Court, will be compromised, perhaps fatally, as examples of judicial colonialism where only the Africans and the defeated can be prosecuted. If you can go after Sudan, but you can't go after the United States, does the whole thing fall apart?
Well, let's look at the facts with the United States and their relationship with the International Criminal Court. Former President Clinton did sign on to the Rome Statute for the International Criminal Court. George W. Bush then sent a note saying, put that signature on hold, and he refused to put the statute to the Senate for advice and for ratification, which is necessary in order to implement it. But under the new Barack Obama administration, he has certainly said, made motions, Hillary Clinton has made motions, maybe warming the relations a little bit. He is certainly, the United States has unique concerns. They are certainly out there on the playing grounds,
well, the
so to speak.
concerns are they don't want Don Rumsfeld being sent to The Hague to go on trial. I mean, that's it, isn't it?
Well, they certainly have definitely their concerns, but that said, I think that this new administration, at least there is hope that there will be some change in the future, that they will warm to the idea of accountability and joining the international community.
When you look at international criminals, though, like the Rwandan fellow we talked about earlier, like Augusto Pinochet, you want to put American administration officials who were behind the Iraq War in the same category?
I'm not sure that I do, but I'm not sure that I don't either. I certainly feel that people should be held accountable for crimes, but I certainly don't believe that the law is the only way to go. Sometimes it is appropriate, and sometimes there might be other methods. And sometimes when you're talking about countries that have turned, started a new chapter, are trying to rebuild and create peace, that sometimes prosecutions can aggravate other values that are important to international security.
Truth and Reconciliation Commissions, for example, might be a better way to go? Is that what you're thinking?
In certain circumstances, yes, where appropriate.
Okay. Jillian, it's good of you to come into TVO tonight and talk to us about this. Thanks so much.
Thank you very much.